Welcome to Talk Law Radio with attorney Todd Marquardt of the Marquardt Law Firm at marquardtlawfirm.com.
Welcome back to Talk Law Radio. I'm Todd Marquardt here with Stephen Countryman from Frost Bank Trust Department. We're talking all about what it's like to be working at the Trust Department today and answer some questions that you might have about whether you should name an individual as a trustee or whether you should name a bank as a trustee, and what kind of trust do they manage, what type of assets do they manage, what are some good circumstances to arrange for a trust. And so I want to talk about people who want to name a family member as trustee. What should they consider when deciding whether their family member is going to be a good trustee or not?
Sophistication level. That's really the heart of it. Can they manage finances? Can they act prudently? Remember, there's a prudent investor rule for the trustee to invest prudently. They shouldn't just let that money sit in a checking account, and they also shouldn't invest in Bitcoin, or at least all in Bitcoin. So if you're an individual and you're just, you have a normal job and you're not a lawyer or a CPA or even in finance, you're going to have a hard time. And there's notice requirements. There's disclosure requirements for the beneficiaries. And it can be a full-time job as well. So you need to have somebody in there who knows what they're doing. Some of that can be mitigated by, in terms of who's the beneficiary. If they are their own trustee and they have a good lawyer, you can get away with it. Certainly, it happens all the time without needing a corporate fiduciary. But if you're going to have contentious family members, a corporate fiduciary is a great option because they get to be the bad guy and say yes and no to trust distributions and to how the funds should be invested. And if you name a corporate fiduciary, you want one that's got a good legacy and a good foundation, because sometimes you get the newer ones and maybe you can get away with a lower fee at the end of the day, but maybe they're not local and it's going to be hard to get a hold of them. And those reporting requirements that you would see from a local institution, they may be slower to respond on. So, it's okay to have individuals as trustees, especially if it's someone that you trust, or you can even name, your lawyer that helps you with the drafting and everything. But eventually they're going to pass too, and trusts tend to be long-lasting entities, and a lot of times they're supposed to be for generations. And the statute of limitations, or not the statute of limitations, but the
rule against perpetuities.
Yeah, right. That thing that I tried to ignore during law school because it's so difficult to understand. In Texas, is now over 200 years, so longer than we've been in a state. So it's having a backstop, at least of a corporate fiduciary, is a nice way to frame a trust. So if you have individuals that are capable and able, that's wonderful. That's the best case scenario. But if you don't, then a corporate fiduciary is a great option. And then when you are naming a corporate fiduciary, you need to get down into which one and why.
Right.
And it's a lot easier to pick a company that's been around for a long time, has a good pedigree, not in the headlines for doing any kind of nefarious things.
Right.
Those are at the baseline.
Well, if somebody's shopping around for a corporate trustee, they've already decided that they don't want to put that burden on their family member. Do you go head to head with other trust departments? Do you talk about what would be good about Frost?
We do. That's my job. So that happens a lot. And I think the savvy, because a lot of times you'll have a group of beneficiaries. Grandpa created a trust and it holds the family ranch, or it holds, just a lot of liquid assets or stocks and bonds. And they're looking for someone to take over, and they don't want it to be each other because they're either adversarial or it has to be a corporate fiduciary per the terms of the document. And the savvy ones will say, well, let's see how low we can get the fee. And, our fee schedule is negotiable to some extent. And I think it really comes down to how much is going to be in there and how complicated the administration is going to be.
Right.
So Frost is not just going to come in and lowball it. we're going to say, well, what are the facts? Who's involved here? How complicated is this? Let us review the document. Are we going to be going to court all the time? Are we going to be dealing with some unique assets here? And if so, then maybe we don't care about being the lowest fee. We want to fee this correctly and still provide what these people are looking for.
Yeah.
But also not undercut ourselves at the same time. So that that's the negotiation process. People want to see performance and they want to see fees, right? Those are the big questions. I think they should also be looking at sophistication level. Can they manage unique assets? Like if there is a family ranch, are they outsourcing that or are they doing it internally? And I can tell you, Frost is a bank that does it internally. We have our own real estate department full of lawyers and real estate agents and people who've worked in title companies and same with oil and gas. We have an oil and gas department. We're the third or fourth largest bank when it comes to mineral management under management in our wealth department in the country. So we're 48th something largest bank in the country and third largest in mineral management and 3 million mineral acres under management. And we have 800,000 plus surface acres under management. And with that management comes lease negotiations, conflict resolution with tenants, paying ad valorem taxes, going out and checking the fence line. I mean, it comes down, we do all of it. And we're going over to the houses and making sure they're in good shape. And then for the oil and gas, it's the same thing. We have some great software that helps us keep up to date with leases and drilling permits and making sure that the allocations are correct and negotiating lease bonuses, all that stuff. So if you have unique assets like that, for us, it's a great place to be. And when we sell real estate, we don't go out and hire a realtor 9 times out of 10. Sometimes we do if it's a really unique property, but most of the time we're selling real property internally. We list it on MLS ourselves. We have real estate agents that do that. But other corporate fiduciaries often will hire a real estate agent who will charge their 3%, and then the bank will charge an additional fee on top of that. So we save our customers some money there on top of everything else. So Frost is a one-stop shop. We like to think that we are. And then the same applies for the family office element, which we don't need to get into. That's kind of a different area. But the idea being you come to us and you say, here's my stuff. I need help.
Yeah.
We can run with it. And that's just from years and years of doing this.
Yeah, some of the first questions people ask me when I'm talking about a corporate fiduciary is, what does it cost? I tell them, yes, there is a cost, but it's worth the fee because they're going to do a better job with whatever the assets are. People don't realize that when you own the assets yourself, you can decide whether to invest or whether to save or whether to spend. And if you make mistakes, you only have yourself to blame. But when you have somebody else that's managing those things, they have a higher duty of care. And so you have both the duty to make sure that there's not very many mistakes and another duty to try and perform, right?
Yep. That prudent investor rule is always in the back of our mind. And we do a lot of different things. We do trust, of course. And I think maybe we can step back and talk a little bit about how the fee schedules work.
Okay.
When people think about asset management, there's 2 types of, broadly speaking, managed fees or fee types of like schedules, for lack of a better word. And you have the managed accounts, which tend to be an annual fee broken down in over 12 months. And that's a percentage. And oftentimes you see the managed fee for a brokerage account around 1%. And the other fee schedule you often see are the trades in a regular brokerage account. So the trades, there's a fee associated with every trade, every buy, every sale transferred. And the wealth department, in most wealth departments, they're all managed fees. It's all based on a percentage. And that percentage goes down with the more assets under management. So that's just a good way to look at it. And our fee schedules kind of run the gambit from whether you're aiming us to just invest the assets that manage what's called an investment management agency, where we're just doing that. We're your agent, and we're going to do whatever you say. You say jump, we say how high. And then we also, of course, serve as trustee of irrevocable trusts and revocable trusts. And our responsibilities are higher, and so our fees are a little higher. But it's not that much higher. It's about, it starts at 1.3, but it goes down. And if you think about it, that's only 30 basis points higher than a regular managed brokerage account. So it's a pretty dang good deal because you get so much more than just the broker. You get the administrators and the attorneys and the specialty asset people. And then and I don't want to leave off the whole, we serve as executor too. I was told once by my predecessor that we have over 10,000 wills in our will vault and a 70% market share when it comes to being named is in people's documents. I don't know how true that is still, but we certainly have over 10,000 wills. People trust us and they name us as a backstop. It's very common. So they'll name their kids, and then if their kids don't survive or aren't able to serve, Frost is the backup. And I think that gives a lot of people peace of mind, is knowing that, well, if they can't do it or they move to Alaska or whatever and they can't serve, Frost can take care of it. And of course, there's a separate fee schedule for serving as executor, but it's 3% on the first $1 million, and then 2.5% on the second, and then it goes down after that to 1.5% over everything over $2 million. So it's a lot of work to serve as an executor, as you well know, Todd, but we're very efficient at it, and we help prevent turmoil within the family.
Yeah.
So we interpret the document, we file the tax returns, we sell all the assets that need to be sold, transfer and distribute all the assets that need to be distributed, and we take care of any kind of tax issues that come with getting appraisals for 706, and we're just, we've been doing it a long time. So it gives people, like I said, a great peace of mind, and it's a very rewarding area too. You learn so much about people after they passed. It's hard to explain, but I find it to be just a very fulfilling element of the job.
You mentioned executor and trustee serving as the quarterback for all those situations. Would the bank ever serve as co-executor or co-trustee with an individual family member?
We sure do, and our fee does not go down for that. As you know, Todd, when you have a co-executor or co-trustee, it tends to be more work because it means 2 signatures on everything, more correspondences, getting on the same page with that person. I will tell you, if it's a low-value estate and we're co-executor or co-trustee, it's not always a great business decision for the bank. But if it's a large relationship, or if they've been a customer for a long time and they're relying on us to help their, say, surviving spouse or child who's not sophisticated, we will absolutely help them. But every bank will tell you it's not their favorite thing to do is serve as a co-fiduciary.
Yeah.
But we absolutely do it. Absolutely.
Okay. There's some other roles that are defined in statute now, like special or independent trustee. So say you have a beneficiary that's a trustee and they have some economic downturn or business setback and they need to have another trustee appointed to protect their trust. Would the bank serve in that type of role?
We do. Independent special trustees come with some issues because of prior acts and also tax returns. Sometimes you're carving out assets and you're saying, I can handle the house, but I need the bank to deal with the investments.
Okay.
So the question becomes, well, okay, if that house or whatever other assets weren't carved out are creating income, who's going to report that? Who's ultimately going to sign the tax return, because we're all operating on the same EIN, but we help with that and clarify all that. So special trustees are kind of, like you said, it's a newer area. I think it's a great expansion because it's a needed area that hasn't existed really much, but we're seeing it more and more because people are just saying, well, look, I don't, or in a settlement agreement. That's where you often see it too, is where families are fighting and they're saying, well, let's just appoint a special trustee to deal with these assets and then we'll distribute the rest per the family settlement agreement. We can't agree on these, so we'll keep it in trust and have Frost take care of it.
Okay, that's a good point. Well, we have to take another break. When we come back, we'll talk about some specific family situations, people situations that a trust is beneficial and how the bank serves as trustees there. Stay tuned. We'll be right back.
This has been Talk Law Radio with attorney Todd Marquardt, brought to you by the Marquardt Law Firm. You can learn more at marquardtlawfirm.com. And be sure to listen to the full Talk Law Radio show Saturday mornings at 11 on 9:30 a.m. The Answer.
Each week, attorney Todd Marquardt talks about the law. His mission with the Talk Law radio show and podcast is to help you discover your legal issue blind spots. In the beginning, God had one law. Don't eat from the fruit of that tree. Then came the 10 Commandments. Now we have federal, state, and municipal lawmakers that won't stop creating new laws. Laws that might impact you without you knowing it. Listen to the show and drop a line on Facebook or email host@talklawradio.com and let the host know what you think of the show, the topics you want to hear, and whether you want to be a guest.